Good afternoon, ma'am. How are you?
I'm well.
Right.
DCJ.
I apologize for earlier. I know that when waiting to be interviewed is one of the, you know,
It's
most,
brutal.
yeah. So, um, you are coming here for the third time, applying for a vacancy in the Northwest High Court.
This is the second time I'm applying for Northwest.
You
The
you
first
you
time
were
it was,
interviewed in April 2021. For which vacancy was that?
it was Northwest DCJ.
And in October 2022?
So the first one, it was for KZN.
Oh, I see. So this is only your second time trying your luck at going back home as you pleaded with us last time.
I'm still pleading.
Okay. We should not be long with you because your CV is familiar to us. But just to remind ourselves, you were a holder of 3 degrees, Juris, LLB and LLM,
Yes, DCJ.
obtained from the Northwest University and Nelson Mandela University.
Yes, DCJ.
Your career has been centered in the Department of Justice, where you started as a clerk in 1989,
Yes, DCJ.
and you worked your way through the ranks. You became a legal administration officer, prosecutor, magistrate, and finally a regional magistrate in 2004.
Yes, DCJ.
And that's the position you still occupy.
That's where I'm still.
You have acted a number of times as a judge, that is.
Yes, DCJ in KZN.
For how long?
The last time I was here, I haven't had any other stint since the last time I was here.
Oh,
The last time I was here, it was like 33 weeks, if I'm not mistaken.
and you do have written judgments.
Yes, DCJ.
Yeah, and I saw that some of them were submitted to this body as late as last week.
Yes, the intention was to respond to a concern that I did not attach any of my high court judgments.
Okay, we'll get to those. Um, the professional bodies have, as you know, on both occasions noted concerns about your candidature, and those persist. And the General Counsel of the Bar, for example, laments, well, they say you have not been exposed to civil litigation. Although you are strong on criminal law, you lack in that area, and they set out where the areas of concern are. And there's a concern that you've hardly done any civil trials, you have not sat nearly enough in the motion court. Apparently, you have only 2 weeks' experience in that court.
No, in the high court, I sat for a session doing motion court.
For how many times have you, how long have you sat in the motion court?
I think it was about 3 in that session.
How long are those?
The session, I think it was about 6 weeks.
Okay. So you were doing motions for
I was doing only
6
motion,
weeks.
both opposed and unopposed.
And unopposed. All right. Well, there's also, well, the one complaint luckily has been dropped, which I thought was serious, where you're accused of absenting yourself from work and not sitting in court through the day, both which were not substantiated.
I did not see that one.
No, they have dropped it. They say there was no substantiation for that for that accusation.
No, I did not even see, not in this time around. I did not see that. And I think it was maybe the first time or the second time. And if you want my response to that, I'll just say there's no truth to that. I have never been absent without leave.
No, well, what I'm trying to say actually is that you have been vindicated because no one has come forward to say to prove that you are actually guilty of that terrible conduct.
I understand.
Yeah. But there's still a concern about late judgments being delivered late.
No, it was that time. I don't have that problem. And I did indicate that time that I once had an issue with files in the regional court when we started civil work in the regional court about the misfiling and files going missing, which has fortunately improved quite a lot. We no longer have that.
All right. We have also been asked to find out if you have any health concerns because you have not completed that part of the questionnaire. Is there anything that you should bring to our attention in that regard?
I suffer from high blood pressure, for which I am on treatment. Other than that, nothing serious. From time to time, I do have this, I think the early onset of arthritis on one of my knees. Other than that, I'm healthy.
Those conditions do not hamper the performance of your work?
No, I do not believe so.
Yeah. All right. I'm going to hand over to Judge President Hendricks to put questions to you.
Thank you, DCJ. Good afternoon, Ms. Mogwera.
Good afternoon, Judge.
How are
Hendricks.
you?
I'm doing well, thank you, sir. How are you?
I'm fine, thank you. Thanks for asking. Ms. Mogwera, just for the record, I called you last year and I wanted to offer you an opportunity to come and act in the Northwest. You confirm that?
I confirm that, sir.
Yeah, and I asked you how many partner matters did you have. You gave me a number, and when I spoke to the then acting regional court president, Andrews, she said, you have more than what you told me. You remember that?
No, may I correct you, sir?
Come again?
May I correct?
Yes.
When we spoke, you didn't ask me about the number of part heads at all. You didn't ask me about the number of part heads. You just asked me, would I be interested? Can I avail myself? I said yes.
No. If my memory serves me well, I even called you a second time. I don't want to belabor this point, to inform you that that is what acting regional court president Andrews told me. You remember that?
Can I correct? I maintain what I'm saying. When you called me, you asked me, you told me you want to offer me a chance to come and act. I said, I'll be very grateful. And then you said, it will be around June. Will I be available? I said yes. And then I said, could you kindly inform the regional court president? You asked me for her number. I did not have it. I said, I will call and thereafter I'll give you the number. Then I gave you the number, you called her.
No.
And then the issue of part heads, after you called me, I called her to tell her that you asked for her number. And I even told her what you'll be calling her about. And I told her, and this is my position as far as my court work is concerned, I have so many part heads. But I have agreed to avail myself because I was told the acting stint will be in June, and that time it was February. So I'm the one who even brought the number of parties to her attention, and she said, okay, I'll wait for his call. Then when you called me, you told me she told you that I have that number of parties, which I confirmed, and I told you that no, my plan was to work through the parties until June. That is what happened, how I remember it happening.
Yeah,
I did not misrepresent the number of parties that I had.
My recollection differs, but it's fine. Let's go to your application. As far as legal background is concerned, it's stated that you mainly did criminal work.
Yes.
And you last acted in the High Court in 2021. Is that correct?
I think I'm not sure. It could be 21 or 22. I'm not really sure.
Yeah. Now, in 9.3, you stated that in 2021, and I quote, in 2021, I did motion court. How many motion courts did you do?
As in sitting in court, it was about 3, doing unopposed motion. But there were times when I would go for, I did 3 opposed motion.
And unopposed?
Unopposed, I would do an average of about 40 files.
Do you have any parted matters?
As we speak, I have 8 parted matters.
8 parted matters.
8. May I explain something about parties, please, JP? The regional court is not like the High Court, I'm sure, or just maybe for the benefit of those who are not aware. It is extremely difficult to start a case and finish it within a week. There are so many problems. The first one is the workload. There's a lot of work in the regional court. Some of the cases that we do, sometimes I feel are cases which could have been taken to the High Court, but they come to the regional court. Of late, there are cases that are supposed, rightly, I believe, that could be done in the district court, but they end up in the regional court. So our workload is, we get an average of 20 new per trial, 20 new matters per month. So it's, unless you just want to finish the cases for the sake of finishing them, so that when you come here, you should appear like somebody who is up to speed because it doesn't have parties. You can do that, but at the end of the day, we want to see justice being done. That's why we have parties, and I'm sure in recognition of this fact, our practice directive says a regional magistrate can have about 15 parties at a time, not exceeding 15.
Okay, thank you. In paragraph 9.6, you listed 5 matters, which was partly at that stage when you applied. How many of these did you finalize? And how many are still outstanding?
I have finalized 3 of these ones, but there are others that I have since started after submitting this questionnaire.
Yes. Do you do civil work in the regional court?
I have been doing civil work from the time when the regional court were given civil jurisdiction. And initially, I was the only one doing it. That would be from around 2012. It is only recently, around 2020, when other colleagues showed interest in civil work, that I went back to the region, to the criminal court, but I have since gone back again to the civil court.
Yeah. What is the workload as far as civil work is concerned in the regional court?
We have a lot of applications. almost every day. On the day, we do our applications on Thursday. So Mondays, about 3 days in a week is for trials. Most of the trials, they end up not proceeding for one reason or another. Then we do divorces. Divorces, we do average of 30 unopposed 30 divorces per week. The one thing that really keeps us busy is divorces and applications. Trials, the numbers are not that high.
Yes. As far as administrative law is concerned, you indicated that you did not do much cases involving administrative law.
Yes, but when I was acting in the High Court, I had occasion to do one application, a PAJA application. Unfortunately, when I sent the cases that I sent last week, it was among those, but for some reason it was not transmitted until around Sunday. I got information that it did not come through because I had to check what cases were received by JSC, and I was told that only 3 were received. I had sent 5, and this PAJA application happens to be among the one that was not transmitted, but I do have a copy of the judgment.
Yes. You also indicated that as far as constitutional law is concerned, almost all matters, if not all, have elements of constitutional law. What do you mean by that?
I mean, if I'm sitting in a criminal court and an issue arises, I have to apply the Constitution. Because the Constitution is like the lens through which we have to do everything that we do. When I'm explaining the right to legal representation, it's Section 35. So we invoke not only in criminal work, even in civil work. When you are dealing with, say, a PI application, you are talking about eviction is the right to housing.
Yes. In the Northwest, between 80 and 90% of the work is civil work and not criminal work in the High Court. Are you aware of this?
I have heard, because I had to inquire from someone who's working there.
Okay. Thank you, DCJ.
Thank you, JB. Acting Premier, do you have questions for this candidate?
No, thanks, DCJ. I think I just have a few questions. And good afternoon, Ms. Mogwera. DCJ, am I audible enough?
Yeah, we can hear you.
Oh, no, okay, no, thank you very much. Ms. Mogwera, just remind me quickly. Did you say, have you acted in the Northwest High Court before or not?
No, I have never acted in Northwest, Commissioner.
Okay, and have you familiarized yourself with the workings of the Northwest High Court?
I've been asking around because I had interest.
Okay. And from where you are sitting, do you think are there challenges in that court?
The last time, the only challenge I heard about, I was told that there was a backlog with criminal matters. That's all. That's the last thing I heard. That I'm not really. I was just interested to know what kind of work, if I do get a chance to act there, what I can expect.
Okay. And then let's quickly talk about representativity. Do you think do we have enough women and people of other races in that court?
Women, the last time I checked, it was the DJP. There is also a white lady, I think, and there was also an Indian lady. I think she has since retired, Judge Gata, if I'm not mistaken. So for now, I think there are two ladies, if I'm not mistaken.
Okay.
And
then,
about three or four men, I'm not sure.
Okay. Okay, and then tell me one thing quickly, because in the Northwest, you will agree that there are issues of traditional leadership and so on. Are you familiar with the Traditional and Quaysand Leadership Act?
Not that much. All I know about traditional leadership is that there was a bill, I think it was traditional courts, the bill that came out in 2008 that never saw the light of day. I'm talking about traditional courts. And then there is it was withdrawn, and one came out again in 2012 and then 2017. But I'm aware that that Constitution, Section 211 of the Constitution, provides that constitutional customary law is a law that is it is a system of law that is akin. It should be given recognition in other ways, the same recognition as common law, and that the courts should apply it where it is applicable. It's subject to the Constitution and the legislation that pertains to customary law.
Okay. Now, DCJ, my last question was related to the same act, because I had wanted to raise a question about the implementability of Section 59 of that act, but I think Mogwera has not as yet familiarized herself with that act. I think I must just leave that one for now. And then the last question, which I hope it will not be controversial. In your opinion, Ms. Mogwera, do you think Section 47, subsection 1E of the Constitution, that deals with convictions of offenses and sentences to a maximum of 24 months imprisonment, do you think contradicts Section 84, subsection 2J, which deals with pardoning, reprieve, and remittance of any fines? Do you think there are contradictions between the two sections, Section 47 and Section 84?
Perhaps if you can just remind me what the Section 47 provides.
Section 47 deals with conviction of an offense and sentence to more than 12 months imprisonment.
Yes.
That's 47. 84-2J, it deals with pardoning, reprieve, and remittance of any sentence. Do you think there are contradictions between these two sections?
It's difficult for me to answer that. I maybe if you could shed more light, contradictions in what sense, I can't follow.
No, that's what I'm asking you. Do you think there are contradictions between the two sections? But if it is a bit difficult, we can leave it. DCJ, that was my last question.
Thank you, Acting Premier. Do you have questions for the candidate, colleagues? Commissioner Marumakhai.
Thank you very much, DCJ. I have a question. I just want us to deal with a sort of a substantive but procedural sort of question in any event. Sometimes, you know, litigants are easy to accuse judges of not having the innate ability to accept when they are wrong. And I'm not talking about you, I'm just saying generally, I'm not talking about you. And sometimes this is demonstrated when they go to, when the judge has made an order and they go to the same judge and say, but you are wrong. We want another court to look at what you did. Perhaps maybe that court can come to a different decision. Based on that, I just want to ask you, when one deals with applications for leave to appeal, obviously what I've just said is not a test. What is it that the court that is seized with that matter, that has made a decision, will come to a conclusion that perhaps maybe another court might do, in other words, allowing the litigant to go to another court? What is like the test that can allow the matter to go to another court?
Thank you for that question, Professor Marumahai. I'll try and answer it this way. We all, that is why the beauty of our system is the appellate powers, this appellate jurisdiction of superior courts. Obviously, when an application like that is brought to you, you need to divorce yourself from your initial thinking about the matter and try and see it from the point of view of the person who's bringing the application before you, and to apply your mind as if you are an outsider, not the person who made the decision. And depending, of course, on the argument that is brought to you pertaining to the merits of the case, then decide if you are convinced that another person, when he looks at this decision, could come to a different finding. It is the only way that you can. But if you are stuck to, I believe that you are guilty in a criminal court, I believe you are guilty and nothing can change my mind. It's not about what you are thinking. It's about what another person, given the same facts.
I was more looking at what the rules actually provide and how the courts have shaped the actual test. But we don't have to take it further. I will accept your question. Thank you very much, DCJ.
Commissioner Nyambe.
Thank you, DCJ. Afternoon.
Afternoon, Commissioner.
Have you seen the comments by the law bodies, all of them?
Yes, I have.
I have just one question. The last time we were here, even though it has been some time, anything that is significant that this time around we have to seriously consider that might have made you to be at a better position than then, that we have to look at now?
When I availed myself after I had been nominated, I also thought about that, because the complaint is not even a complaint or criticism from the law bodies, it's a concern. And I don't have any problem with the concern. As far as I'm concerned, it is legitimate concern. I'm sure I would have that same concern if I were in their position. But I want to explain this way. When I availed myself to come before to submit my name again for reconsideration, I deliberately submitted only my regional court judgments, civil judgments, with the view that because I've been before this commission before and because this concern has been raised before, I do not even stand a chance. They will look at this and say nothing has changed as far as the civil work in the High Court is concerned. And I told myself, if they consider this something that is worth giving me a chance, that is worth considering for the purpose of giving me a chance, then I take it that they believe that there is something in me, there's some potential in me to be able to stand for this position. I have not been to the High Court since that time, like I say. Of course, it depends on invitation, and you make yourself available. If you are not invited, you don't stand a chance of accumulating experience. But, and I want to reiterate this, having worked in the High Court, that one stint doing motion court, I got the confidence that I could do this because I coped very well. The rules are the same, almost identical, and I could handle that in the High Court. I could handle the motion court like I do in the regional court. I could engage with counsel if I don't understand anything, and I even wrote judgments that in motion court judgments. So I can't say a lot has changed as such, but I can only offer what I have. What I cannot have experience in the High Court if I don't get a chance to sit in the High Court and gain that experience. But I'm confident that I can handle work that will be given to me. And I'm prepared. Can I also say that for anything that I lack in terms of civil experience in the High Court, because I'm a type of person who doesn't like to be the weakest link, I'm prepared. I'm naturally a hard worker. I'm prepared to work even harder than, so that I bring myself up to speed and I don't become the weakest link. I don't know if that answers you, Commissioner.
It does. The last one, the last time you were here, I'm happy you said nothing much has changed. The last time you were here, Prof. Marumokhai and Advocate Ntukaito engaged you about your judgment. And Commissioner Magwanish dealt with the issue of starting court late that was coming from Advocate for Transformation. I got the same sense when you're dealing with the JP about the issue of the calls, how you dealt with them, that indeed there's nothing much that has changed. So I invite you to comment about that so that I can be fair to you when we have our own closed session for deliberations. Because when you engage the JP now about the calls, I was more confused. I don't know who's telling us the correct version of what happened in that call. But I remember the last time we were here about the issue of starting court late and how you adjourned, and it was coming from the law bodies. And I got the same sense even today. That is why I ask about what has changed.
Thank you, Commissioner. I maintain, I remember very well what happened when I engaged with the JP. The JP phoned me, he was in...
You've already given us your version.
Yes, I maintain
we don't want to be bogged down in a dispute of fact.
Okay,
Yeah.
Thank you, DCJ. What I say is how I remember things happening. The engagement, the last engagement with Professor Marumokhai and Advocate Ntukaito, I agree that the way I had handled the case that they were complaining about is not how I could have done better in that case. I accept. And we all err. That was an error on my part, and we learn from errors. It's not that I want to be argumentative, Commissioner, because I get the impression that you are implying that I'm argumentative. I will not concede to something that did not happen the way I know it. And I have interest in that matter. That is why I can say with certainty how the whole issue unfolded.
Thank you, DCJ.
Yeah. Commissioner Singh?
Thank you very much, DCJ. It's a very short one. Good afternoon.
Good afternoon.
Born in the Northwest, started off in Port Elizabeth, then Durban. Now you want to go back to the Northwest. I think KZN seems to be your home now, your adopted home. You've applied for a post in KZN before. Are you aware of any vacancies that may come up in KZN, or have you applied for any vacancies since you last came before us?
Not really. Since I was here, I applied once. I was not shortlisted. In fact, it was the time when I had applied for both Northwest and KZN. I was not shortlisted for KZN. I was shortlisted for Northwest. And since that time, I have not applied again because, as I indicated last time when I was here, I would really, really want to go back home to the Northwest, back to my home.
So that's the reason that's driving you. And there are vacancies that have come up in KZN that you
I think there was, after that shortlisting, there was only one for which I did not apply.
Thank you. Thank you.
Any further questions for the candidate? Commissioner Dodov?
Thank you very much, DCJ. Just good afternoon, Magistrate Mogwera.
Good afternoon, Commissioner.
Most of the questions were asked by commissioners, including the acting Premier of the Northwest. I will not repeat those questions. But there remain a concern for me. As I listen to the JP of the Northwest, many cases that are handled in his division pertains to civil cases more than criminal cases, and I can see that you have a very strong background on criminal cases. And just now, you've just considered about the matter that was raised by Advocate Nkaitobi and Professor, yes, that you accept wholeheartedly the mistake. And again, listening to what the JP was saying in respect of the fact that he was willing to integrate you, to give you the opportunity to act, and you were willing to act. Don't you think that you need more time to, I'm just asking because there's a matter that is in my head. Don't you think that you need more time to act so that you get exposure in respect of the civil matter, so that for the implication of the future perspective, you are okay, you are better off in that respect? Don't you think that could be the best way forward? Thank you.
I could never say, thank you, Commissioner. I could never say no to being given a chance to act. In fact, that's something that I have been praying for. However, having said that, I would really want to urge this commission to judge my competence in the civil work from the work that I have submitted to you. If maybe because I've submitted, I think, a judgment, one civil judgment, I have submitted even a civil appeal that I had the opportunity to scribe. I have submitted an application judgment, and judge from there if, despite my lack of a long exposure in the civil court at high court level, I do not understand how to write a judgment. I do not have knowledge of the law to analyze the evidence, all the things that are required in a judicial officer when he's writing a judgment. If you feel that I am lacking, then I would concede that I am not there yet. But I believe that I can handle the work.
Okay, I was just asking that question. Thank you very much, DCJ.
Could I ask for a follow-up to this point?
Yes, Commissioner Goito.
Yes, Judge, so yes, you've been saying to us, no, we should consider you for civil practice, and you've now accumulated enough experience, and that it may have been okay on the last occasion not to accept you based on lack of experience. That's my understanding broadly of your thesis today.
Yes.
Yes. Now, I just want to ask you one or two civil procedure questions on things that emerge daily in the civil courts. All right, it's not an exam, but it's just to get a practical sense of the extent of your knowledge. So an application is brought as a motion, and a dispute of fact arises, in your opinion, that is not resolvable on the facts. And there is a High Court rule, which is 6.5G. What are the three options that that rule permits to the judge?
You may decide the application on the facts that are not disputed.
No. You have decided. That's why I'm saying 6.5G is not for that. That's plus con Evans. It is where you cannot decide the case because there is an irresolvable dispute of fact. Mm-hmm. And then you have three options under Rule 6.5G. What are those options and how do they differ?
You may refer the case to oral evidence if the disputes are of a narrow nature.
And what should you do when you refer it to oral evidence under that rule?
It's just that I would have preferred if you gave me because we are talking about High Court rules. I'm used to but they are similar.
But no, but you want the job in the High Court. That's why I'm asking you about the High Court.
Yeah, you decide if the issues that are in dispute are narrow. If those issues are narrow, they do not require that the case we refer to for trial, you refer it for oral evidence. I don't know if I'm answering you. And then if the issues are very broad, then you may refer the case for trial. And the affidavits that have been submitted, they act as your pleadings. In a case like that, you can even invite the parties to file supplementary affidavits.
Yes.
Do you want me to continue?
Yes, and that's what I asked for. It's an open question.
Or the case may be dismissed. You can dismiss the application outright because, especially where the dispute was foreseeable, it's something that the applicant should have anticipated will happen.
Yes, and what are the conditions when you are referring the matter to oral evidence, and how does that differ to referring the matter to trial?
When you are referring it for oral evidence, they only have to deal with that specific aspect.
Yes, but what should the judge do? So you are now judging, and you think, well, I must now choose trial, oral evidence. What should you do under the rule?
I think the determining factor is the nature of the dispute itself.
Yes, but once you've decided it's oral evidence, what should you do under that rule?
Maybe something that I haven't really thought of.
All right. Thank you, TCJ.
Oopsie. Are there questions from the virtual platform? No.
No, thank you, TCJ.
Thank you. Do you have any questions for us, Ms. Mogwera? We've run out from our end.
Perhaps just to reiterate what I said to DCJ, that I would really appreciate if you judge me on what I have placed before you. Of course, some things, when you have to do something, you have to go and research. As long as you know where to find the law, you can never go wrong. I'm the type of person also who is not afraid to approach and ask for advice where I'm not sure. That is all I would like to bring to the attention of
We've had
the commission, and also to thank you for the opportunity for inviting me once more. And I hope that things will go well. I thank you so much.
Okay. Well, thanks to you too for making yourself available. And let's see how it goes. You have 2 competitors, so
Thank you.
yeah. Thank you, Ms. Mogwera. You're excused.